first matter to come before the court this morning is in re SC and I.O.C. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes. If you'd like to reserve that time, and you let me know when you get started, I'm keeping the clock this morning, keep you apprised of the passage of time. We've read the briefs and are ready to proceed when you are.
Thank you, Your Honor. I'll reserve 5 minutes. May it please the court. My name is Neil Agarwal. I represent the appellant, Mary Donovan, the mother of these 2 children. Your Honor, I'll move right into my first assignment of error. Back on December 28, 2013, the juvenile judge issued a dispositional order after the children were found dependent. The order, and I have it right here in front of me, is dated December 28, 2013, is signed by Judge Teodosio, and it lists 7 orders. 1, the allegations of the children are abused shall be dismissed as withdrawn. The child SC shall be adjudicated as a dependent neglected child. 3, both children shall be placed in temporary custody of children's services. 4, mother shall provide the names of all relatives on both sides of the children's family that she could provide for them. 5, parents will not speak negatively about one another or another party in the case of the children. 6, the review of the dispositional order shall be scheduled for March 11th. And number 7, child support enforcement agency shall credit payments made by one of the child's fathers. That is the dispositional order from the judge. Nowhere in her order does she adopt, mention, discuss, or indicate anywhere that a case plan has been adopted as an order of the court or made binding on any of the parties. It is mandatory under the juvenile law, under 2151-353E, under Juvenile Rule 34F, and under 2151-412E, that the court shall, at the time of disposition, adopt a case plan. Now, because no case plan has ever been adopted in this matter, it was improper for the court to grant permanent custody on the grounds that mom did not comply with her case plan. The case plan is non-existent, is non-binding. There's no mechanism by the juvenile court to order mom to engage in any services whatsoever. Nothing.
We held that to be the case, that no one is bound unless the case plan is formally adopted. I know that we have, at least I believe, I remember that we have said that parties are not bound to terms that are not included in the case plan.
This court has held as recently as in re LF, Your Honor, paragraph 37, that if there's no court-ordered treatment or services, you cannot hold mom liable for not doing it. So in this case, there is no case plan. There has never been a case plan that's been adopted or considered by the magistrate or by the juvenile judge. Now, in response, the state is saying, well, they're saying a couple things. One, they're saying when the trial court put the children in the temporary custody of the agency at the disposition, that was somehow an adoption of the case plan. Well, putting children in temporary custody of the agency has nothing to do with the adoption of the case plan. Okay, they are not one and the same, and the court has to specifically say, we are adopting this case plan, it is binding, it is an order of the court, it shall be enforceable. Again, that was never done. So I don't understand, and they cited no case law, no statute, no rule to say when children are put in the temporary custody of the agency, that is somehow an adoption of the case plan. And then second, and more importantly, they say it's harmless error that the court never adopted a case plan. Now, I can't think of a more egregious error than granting permanent custody on the basis that mom didn't do her case plan when there was no case plan. Now, the state is saying, well, mom knew the requirements of the case plan, and therefore the fact that she didn't have to do it is irrelevant. That the agency could have got permanent custody irrespective of her ability to comply with the case plan. Well, the judge didn't certainly think so. she said the mom has not complied with her court-ordered case plan, and I'm going to grant permanent custody. And I will speak about that more in my second assignment error. But I would say, first, is the language in the statutes is shall. Now, the Ohio Supreme Court has held time and time again, shall is a mandatory duty. If the trial court did not adopt the case plan, well, they certainly didn't think it was in the best interest of the child. Now, I will note that the magistrate, in those 7 orders that I wrote for the magistrate, for the judge, I read earlier, are exactly the same that the magistrate also found when she issued the dispositional order. However, in her findings, she said, well, the parents agreed to the adoption of the case plan as a court order. There are a number of things wrong with that. The statute specifically says, if the parties agree to the case plan, the court shall adopt it. And second, if the parties for whatever reason don't agree to the case plan, the court has to consider it as what is in the best interest for the adoption of the case plan. So, if we assume that the parties somehow agreed to the adoption of the case plan, the magistrate did not adopt it, and even more importantly, the judge, when she issued her ruling, did not adopt it. Now, this court has said time and time again, it does not look at what the magistrate did. It looks at what the judge did. So even if we assume, as a matter of course, that the magistrate somehow adopted the case plan, so what? It's not what the magistrate did, it is what the judge did. And if the judge did not adopt the case plan, it doesn't matter if the parties agreed to it, it doesn't matter if the magistrate agreed to it. If it's not adopted, it's not adopted. And because of that, there are no court-ordered services, there is nothing to be done. Now finally, I would note that neither the mother nor the agencies appealed from the magistrate and really the judge's ruling not adopting the case plan. And they're saying, well, that argument is waived. Very importantly though, if there is no adoption of the case plan, that is not a prejudice on the mother, that is a prejudice on the agency. Because they cannot make mom do anything, and they should not be able to get permanent custody or say mom has failed to comply with the case plan when they themselves did not object to the court not adopting a case plan. So in retrospect, neither party adopted or had any problem with the court not adopting the case plan, but at the end of the day, who's been harmed more? We're arguing is the agency. They had a burden, and it should have been their duty to appeal or file objections to the judge's lack of adopting of the case plan.
So what's the remedy?
Well, you have to go back to the original disposition. And we're back to the original disposition, and you have everything subsequent from the date of the disposition hearing, I would argue is void ab initio. So we have to go back to the dispo. You have got to have a valid case plan. If you don't have a valid case plan, you don't have a valid dispositional hearing or a dispositional ruling, and everything is void. Not voidable, but void. Then finally, I want to move on to my second assignment of error. The judge granted permanent custody on, it was not a 12 to 22. Because it's not 12 to 22, the judge had to find what we call the E factors under 2151-414. Here, the court found 3 E factors, E1, E2, and E4. E1 is basically that the mom failed to remedy the conditions that led to the initial removal. Now, at the adjudication, the magistrate nor the judge made any findings as the basis of the removal. It was just a finding of a stipulation to a dependency. So we have no knowledge, we have no basis as to what were the initial conditions that led to the removal. The state lists a number of allegations that they put in their complaint, but as this court held, allegations are unproven statements. They have no meaning or force of law. So it doesn't matter what is in the complaint, it was what was found by the magistrate and the judge at the adjudicatory ruling. There were no findings, so therefore you can't remedy the conditions that were unfound. Second of all, the conditions were that the mom had such severe, and this also gets back into the E2 and E4, that she had such severe mental health issues that she was unable to provide or care for these children. However, the evidence will show she saw her children, she attempted to see her children without fail at every visit. She brought food, She brought toys, she brought games, she was very loving and engaged. Nobody has disputed that her visits with the children were adequate, that she gave Christmas gifts, she brought them presents, she brought them, again, food. She did everything she can. She had a job, she had employment, she had a house. So her mental health was not to the point of to such a disabilitating degree that she could not care for these children.
And Council, you're just now reaching the 5 minutes of rebuttal time.
Thank you, Your Honor. And then under the E2 factor, they also, or the E4 factor, is that mom failed to rightly support or visit these children. But the evidence is she paid support as soon as the court ordered it. Nobody is saying mom didn't pay any child support, and she visited the children as much as she could. There was a lot of dispute over the visit because the agency had some problems at the library or the agency. She tried to get a pastor, she tried to get other visits. And the judge said, they alleged an allegation of abandonment. The court says, I'm not going to find abandonment because mom attempted to make visits. So if she made enough to attempt to make visits, that's enough also to say she engaged and tried to support the children. And with that, Your Honor, I'd like to reserve the balance of my time. Thank you.
May it please the court, Kevin DiMartino on behalf of Summit County Children's Services Board, the appellee in this matter. We are asking that this court affirm the trial court's decision bringing permanent custody of these two children to the agency. With regard to the first assignment of error, this court has held in NRA-LF that when a court fails to adopt a case plan, that the test is to see whether there was prejudicial error by that failure, and then to see whether or not the objection, the error was preserved for appeal. So therefore, the obligation is on the parent to preserve that. In the cases that this court has looked at, it was NRA-LF, and I believe Thomas before that, where parents attempted to raise an argument. This court held that first you have to see if it's preserved, and then you go into the second step. So this idea that only the agency is prejudiced if there's no case plan, and that we have this obligation to assert that there was no case plan it's bizarre. The goal of the agency is to provide care to parents so that they can be reunified. We, in this case, we had a case plan prepared. The parents, mom and both dads, agreed to the case plan. The magistrate did note in the dispositional order that the case plan was stipulated to by the parents. And the agency takes the position that that court statement and the understanding throughout this case that mom and both fathers were in agreement with the case plan, that at review hearings they talked about compliance with the case plan, that every amended case plan continued to talk about mother's mental health. All the parties acted as if they were in agreement that there was a case plan and these were the objectives. So to say that the agency had an obligation to object, one, the agency disagrees, and two, why or how would the agency even file an objection in this case when the agency's position was that there was a case plan, that it was valid, and that it was adopted by the court through its statement and through the fact that the parents stipulated to the case plan.
What is the statement that you're referencing that adopted the case plan?
The statement is the same statement that Attorney Agarwal read. That's in the 28th day of December journal entry by the magistrate that says that the stipulation was by the parents as to the case plan being adopted by the court. His true argument is that even though the magistrate made that notation, that finding, it's not in the finding section, but it's in the journal entry, the parties agree to the case plan being adopted by the court. His whole argument is that there is no number 8 in that journal entry that says, and it is so adopted. I mean, this is not.
I thought his argument was that the trial court did not adopt.
His argument is that, and if it had been there in number 8, then when the judge adopted that order, it would be there. But the judge adopted the findings of the magistrate. Clearly, this is not like the cases he cites to with, SDM and SR, where there's an initial case plan, and then mom agrees to it, dad agrees to it, they're working their case plan, and then the caseworker says, I also think you have a substance abuse issue, I'd like you to go get an assessment, but it's never put on the case plan, but it gets brought up at the permanent custody hearing. And in those cases, this court has said, we cannot hold a parent to that. It's not on the case plan. The case plan is the roadmap to get your child back, and we're not going to hold you to that. This case is completely different. There was a case plan. There's no dispute there was a case plan. Mother makes no argument that she was unaware of the case plan, that she was unaware that she had to have a mental health assessment. She doesn't argue with the court's finding or the doctor's finding that she is unable at this time to have her children without supervision. This is not a case where there's an obligation to a parent and the argument is, well, they didn't know. This mother knew the entire time and worked minimally towards that. She didn't comply, but she knew what the objectives were and she was working towards it. So therefore, the agency argues that this case is completely different than the cases cited by appellant in his brief. SR was a case that involved a dad that the agency knew who he was, and for whatever reason he wasn't put on the case plan. That is an exceptional case. The finding for that case that with regard to the case plan has absolutely no bearing on this case. That was limited specifically to that very unique fact pattern that was in that case. In LF, the issue there was a proposed case plan, and this court said a proposed case plan has no binding effect because it hasn't been journalized, and there was therefore no authority for a father to have to submit to a supplemental assessment. So that was a proposed case plan. Here we have case plans. We have case plans that have been filed with the court and that consistently have mother needing to have mental health. So this case is even different than LF in that that was a proposed case plan, and two, it was something supplemental. These amendments have been like, mother will engage in mental health assessment, and then the amendment is mother will comply with the things that Summit Psych said that she should do, which all go back to mental health assessment.
But doesn't the entry of the permanent custody say that mother fails to admit that she's mentally ill or in need of mental health services? Isn't she always refuting that?
She's always refuting that, and that's part of the problem, is that she lacks insight into the fact that she has a mental health issue, and that's what both caseworkers testified to as well as the doctor. That's part of her mental health issue. She complied to the extent that she had her assessment. She did the things that she needs to, but she has been very, I don't want to say belligerent, but not in agreement with CSB. And if you look through the transcript and some of the issues, she wouldn't take her children to certain visitations because she doesn't agree with what the agency says she has to do. She doesn't agree that she has a mental health issue. She doesn't agree that it was inappropriate to leave the children at home in a filthy home the way she did. So yes, she doesn't agree, but that doesn't mean that she doesn't have a mental health issue. That's actually part of the problem, compounding things in this case, is she has no insight into the fact that her mental health is prohibiting her ability to provide adequate care to her children.
Right, so I think the court used the language pervasive, disillusional disorder.
Right.
And then early on, this problem is identified or evidence is given to the trial court. This is a problem, and
Correct.
she is not able. She needs to remedy this problem.
Correct.
And inside of the case plan that was not adopted would be those services that would help her remedy that, right?
Correct.
But the case plan was not adopted. I understand, I'm sorry, counsel is arguing plain error as well.
Right.
That this
Right.
thing, so it's not just whether or not it was the agency's burden to make that objection and make the case plan made, but also that there's just plain error here. And I'm struggling with how we go back from the permanent custody order with these findings of failure to remedy and pervasive delusional disorder that she is contesting throughout the proceedings.
Well,
I find that it's not plain error that this adoption of the case plan did not.
well, regardless of whether the case plan was adopted, so the fact that there isn't that second entry, in the dispositional order that says, and the case plan that I just said the parties stipulate to being adopted by the court, I hereby order. That little part, it has no prejudicial effect in this case. It would absolutely affect the outcome in no way because mother was aware of all of the case plan objectives. She knew from the beginning the issue was mental health. She was given services. The court found that the agency engaged in reasonable efforts. So there is no plain error here. And this court has held that it's not a reversible error if there is no case plan adopted. It is error, and that the court then has to look at whether or not the effect was so much that it would be prejudicial or basically harmless. And in this case, there is nothing that would have happened differently if that journal entry was adopted. Like I said from the beginning, everybody in this case, I believed going all the way through, believed that the case plan was adopted. It's filed, there's a reference to the stipulation, mother's working towards those objectives. So to say that by not adding it is adopted into that entry would have some effect on this case is just not true. There's nothing that would have been done differently. And mother did not object at any point to there not being a case plan, quote unquote, adopted, did not file a objection per se to what the caseworkers were asking her to do. So therefore, she did not properly preserve this issue for appeal. And it is very disingenuous to me, as a parent especially, to work a case plan for 2 years with this belief that you're doing the right thing for your child, you want what's in the child's best interest, but you say nothing about the case plan until the agency grants permanent custody, and now you want another 2 years for the child to be in the custody of the agency to work the case plan. It doesn't seem, it certainly doesn't seem like clean hands to come in and say there's an error when you've been working a case plan, and to act like you weren't aware of it. It's certainly not in the child's best interest to wait. If you want to say the best interest of the child is what we're looking at and is what we should be, then this court should find that there was a stipulation as to the agreement of the case plan, that the parties proceeded as if it were adopted. If technically the way the magistrate went about her journal entry was not proper and the court not specifically adopting it after that, it's still clear that the parties were working with that case plan. There's no argument if there was some objective that they didn't know about, and therefore if it was error, it should not be reversible error, it should be harmless error. It certainly doesn't come to the goal for standard in this case. With regard to the finding for permanent custody, the E1, E2, and E4 factors, the court found that mother did not remedy the conditions that brought the child into the care of the agency. Again, those are mental health issues. That finding and the E2 finding is clearly supported by the record, by the testimony of the caseworker and of the psychologist. And the E4 factor, the lack of commitment, that wasn't based on her failure to visit, that was based on inconsistent visitation on page 327 as part of it. But beyond that, it was that mother wouldn't do the things on her case plan, and then when she visited with the girls, at one point she made comments to one of the caseworkers. She refused to have visits at the library. She'd only visit at the church. She just did everything to make everything more and more difficult, and probably a result or a outcome of her mental health issue. But that was what the basis was, by her failure to, one, regularly visit, and also the unwillingness to do the things that she needed to do to be able to provide a permanent home that was in the best interest of her children. There's nothing further at this time. Thank you, Your Honors.
Counsel, you have just over 4 minutes remaining.
Thank you, Your Honor. May it please the court. Your Honor, this court held in Emory MS, any claim of trial court error must be based on the actions of the trial court, not on the magistrate's findings or proposed decision. So again, the state is conceding the magistrate talked about a case plan but didn't adopt it, and she concedes that nowhere in the judge's ruling, the trial court journal entries, the only one before this court, did the trial court in any way, shape, or form say it was adopting a case plan. Now they're saying, well, that's a technical harmless error. Well, one, in a permanent custody, mother is entitled to every procedural and substantive due process. It is a death penalty type case. And second of all, it is not a harmless or technical error. It is the linchpin of what gives the court the ability to order mom to do services, to engage in treatment, to engage in actions. And they're saying it wouldn't have made any difference at the permanent custody trial, but during the permanent custody trial, they started bringing mom's physician to talk about the mental health treatment. Mom's attorney objected, saying this is all confidential and privileged. The judge said it's overruled because of the case plan. Now, if there was no case plan, then everything mom did for treatment and health is all confidential and privileged because in court, because mom, there was no waiver of mom's confidential privilege with her physician. The only way to get it in is through a case plan that's been adopted and approved by the trial court. So if there is no case plan, there is no waiver of mom's mental health or no ability to overcome that. So during the PC, she goes, this is all privileged and confidential. The judge says, no, there is a valid and adopted case plan, overruled. That's an error. So again, to say somehow it's harmless, I can't think of a more opposite of harmless error than to say the lack of a case plan. And to say the court implicitly adopted it, that doesn't exist by law. There's no implicit adoption of the case plan. If the court didn't think it was adopted, it should be because it's not in the best interest of the children, she didn't put it in. Silence is not an adoption of a case plan. And again, if the court thought there was, should have been adopted, it's just one-line sentence, the court finds that the case plan is in the best interest of the children and is being adopted as an order of the court. It refused to do so. And because it refused to do so, there's no case plan, there's no ordered services, and the permanent custody is therefore deficient. So if there's no further questions, I ask the court to reverse and remand for further proceeding. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website. Thank you both.
Thank you.